The main issue with fixtures is whether or not they are part of real property. In a common fixture ownership problem, step 1 is the purchase and sale. I'll sell you my house for $300,000. Deal. Can I help you? I just came back to pick up my oven. Step 2. The seller wants certain property back. In a divided fixture ownership problem, what are you doing? This is my fridge. My lease is up, so I'm taking it with me. Chattels that lose their individual identity and become part of a structure are real property, like these wooden planks. They become a hardwood floor in a home or apartment. They are part of the real property. Chattels whose removal would cause unreasonable property damage are fixtures. The objective intent of a person who attached it determines whether it's a fixture. This RV is personal property and thus not a fixture because it is easily removable and it does not damage property when removed. Custom cabinets and other chattels that are customized for use at a particular property are fixtures even before they're installed. I'm here to take back my oil derrick. But I thought it was part of the land. The intent test determines who owns the oil well. Would a reasonable purchaser expect it to be a fixture? Ultimately, the intent of the seller must be examined. Parties may suspend default fixture rules in the deed. This deed gives O the right to remove the oil derrick. I'm here to take back my oil derrick. But I thought it was part of the land. Because the parties agreed, the terms of the deed control. O may remove the oil derrick. Parties may determine fixtures in the lease. This agreement between the parties says the tenant can install a washer and dryer, but they will be fixtures. I'm sure glad I installed my washer and dryer. Tenant has installed things considered fixtures under the lease. Hey, you can't take those, they're fixtures. The terms of the lease control. The washer and dryer are fixtures. Tenant's lease has just expired. Removing my shed damaged the lawn. He has a duty to repair damage caused by removing chattels. O deeds Blackacre to A for life, then to B. A has a life estate in Blackacre, and B is a remainder man. Almost finished assembling my new chattel. Chattels A adds to the property must be removed during his life tenancy. If not, now that A's died, the woodshed is mine. The woodshed is now annexed to Blackacre and belongs to B. Owners and licensees can negotiate the removal of chattels. You can fish in my pond, but you'll have to remove the old dock. Sure thing. If the licensee removes, he must pay for any damage he causes to the land. O's property is being foreclosed. Will the bank get this shed that I built? It depends on whether O intended for the shed to become a permanent part of the property. A mortgage creates two parties. A mortgagor, I want to mortgage my house, and a mortgagee. Okay, sign here. 2 months later. Just sign this lease and this place is yours for 5 years. The chandelier is a fixture in existence prior to the lease. It is therefore subject to the mortgagee's or bank's interest. T has just leased O's house for a 2-year term. I want to install a wet bar, which I'll take with me when I leave. Fine by me. If O later mortgages the house, T's wet bar will not be subject to the mortgage. This time, T did not inform O of the installation. I'm glad I finally got this wet bar installed. If O later mortgages the house, the wet bar will be subject to the mortgage if it is determined to be a fixture. I need a loan. I'll put my furnace up as collateral. Sure. Bank 1 promptly files a financing statement, which meets the requirements of a fixture filing covering the furnace. 5 months later, I need a mortgage on my house. Sure. Bank 2 promptly records the mortgage. Question: if O defaults on his furnace payments and the mortgage on his house, whose interest in the furnace prevails, Bank 1 or Bank 2? Bank 1's interest prevails because Bank 1 recorded first.